Now that we're looking eye to eye, you're going to answer something.
So explain to me how 3 different agencies had time to set up and take everyone down.
The word omerta. The word omerta.
Like you, be strong to hold the powers of the sun. To dream, believe.
Let's listen to Pavarotti.
Can I be your superhero?
Hello. Welcome to the...
This is Murphy.
You're never going to learn, are you? Well, that'll shut him up. Welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And I've got a good one for you today, folks. We're going to cover a few topics. Before I get into the main subject, where we're going to look at some very, very interesting information as it relates to this case. First, I've got to clear up some confusion. There's a lot of people out there that seem to get confused really easily. And I'm not going to be mean to any content creators in this one, but I'm going to answer some of their questions. I noticed one had made a video and then posted something in my comments. So I want to clear that up, and I'm not necessarily going to show them where they're wrong, but I'm going to show them where they're wrong. And then I'm going to do a quick magic trick, because I seen last night or maybe the night before where a content creator, pretty good size one, was doing a video on, they was doing a video on the Pro Burgers. I'm not a pro burger. I found the truth in the case. So I'm trying to get the truth out there so they don't convict an innocent guy. But they were doing a video, and she was showing a video of, I guess, a lawyer that was breaking down some of my interpretations of the hearing. And what I want to do is I'll show you what they were saying about my interpretations, and then I'm going to show them a magic trick and show them where... That's what I say about when attorneys watch the case. I mean, all they can think about is arguments. But I'm going to show them a magic trick, and I don't think they'll look at my interpretations of the hearings the same way after I show them that magic trick. But I want to do that first, and then we're going to get into some really interesting information about the case that I think you're really going to enjoy learning. And it's eye-opening, and it piggybacks on the video that I did yesterday on M&D and their correlation to this case and the Aryan family case. Pretty big stuff there. And then also I wanted to let some of my people who's been with me for a long time, like my buddy Gio. He's been with me since day one, and he's always kept me kind of within the lines on some things. So him and many others like him. But he asked that I would do a member video, and I'm sure that's because he wants to, he wants to talk, out of the airwaves. So I will. I wanted to tell y'all on Friday, I'll send out a post later today for members to respond to. Then on Friday, I'll do a member video, and I'll go over your responses like I used to do. So hopefully that's what you wanted, Gio. But before I do all that, we're going to get right into this one. The first one I want to do is I want to respond to a comment that was made by another content creator, and it wasn't a negative comment. I'm not going to be negative, but they were discussing the fact that they believed they heard somehow in the hearing that the vehicle on Ridge Road was identified as a later model Hyundai Elantra. And I got to tell you, nowhere in the hearing did they ever discuss identifying an Elantra past 2013. Not once. And Ann Taylor made it clear that the video of the vehicle on Ridge Road was the one that they identified. It was the only one they identified, and they identified it as a 2011 to 13. And I'll prove that once again just so that there's no confusion for them. Let's go ahead and do that first.
Near 1122 King Road, you can't tell what kind of car it is. They don't tell the magistrate that that's an impossible car, that their expert can't make an identification off that. They don't tell the magistrate that this is pieced together from various other videos throughout the area. The next issue is the year of the car. Law enforcement works with the FBI to determine the year of the car, and the FBI provides some possibilities after numerous submissions to them. And finally, after several submissions, that's when the FBI IML says, I can make a car identification. The issue with that that's not disclosed to the magistrate is that car appears one time on one video.
The video that is clear, well, they take issue with that video because, and specifically, we're talking about 1125 Ridge Road.
And not any of the others that they try to say are the path. It's not, let me see if I can say this right. It's not following a consistent trail where the one camera that can identify the car, where it appears again. It appears one time. And that's what law enforcement relied on. And then what law enforcement did was they took several videos from all over the area and said, well, it's the same car, and we have an identification. That's not all. The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra. The next issue is the year of the car. The issue with that that's not disclosed to the magistrate is that car appears one time on one video.
The video that is clear, well, they take issue with that video because, and specifically, we're talking about 1125 Ridge Road.
The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra.
Hope that clears that up. I mean, that is unequivocally what they meant. The only video that they could identify the Elantra on was the Ridge Road video, and they identified it as an 11 to 13. Now, I understand, Ms. Lucent, that you went through the trouble of trying to put together a video, trying to make it look like it was some later year model, obviously in an attempt to make that vehicle identify itself as Jack D's. But, I mean, give me a break. All the folks out there screaming Jack D at this point. Jack D, the university is going to protect Jack D. I mean, come on. It's just making everybody look dumb. Anybody that's saying the Jack D stuff is making everybody else look dumb. I mean, they just, Jack, with all the stuff that we've uncovered, I mean, we're still going back to the Jack D. Come on. No, it was identified as an 11 to 13, and it was on the Ridge Road camera. If you can't watch that and determine it from that, I don't know what to tell you. But my next thing I want to get into was that video I was talking about that somebody did the other day. And the video, their concept was about the Pro Burgers, but the specific clip that they wanted to show of my video was the clip where I was going through, just like we just listened to right there, and I made the statement that when the defense goes through and clearly discusses the evidence in the case, and then the prosecutor gets up and they don't refute the evidence, well, that is a way for us to determine the truth about the matter. Now, their response is, well, that's just an argument. They're not discussing actual evidence. You can't take facts from actual evidence, and you're confusing the facts. Oh, really? Well, that may be the case, except if you are absolutely, I mean, practically obsessed with the facts of the case, and you've been through the PCA about 1,000 times, you can pretty much recite it, and you've been through every court doc, and you've watched every hearing multiple times. Well, you see, it puts you in a little bit different perspective when you're watching things in the hearing and you hear certain things. It answers questions for you. And then when the prosecution doesn't refute it, you know those questions that it answered for you are correct. So just to prove what I'm saying right now, I'm going to show you the clip from that video of them showing my video and talking about it. And then I'm going to show them a magic trick, because one of the statements they make was, this is not evidence. This is not an expert on the stand giving evidence. This is just lawyers making arguments. Okay, well, number one, you forgot the context of the hearing. That was an evidentiary hearing in order to get a Franks hearing. So all that hearing discussed was the factual evidence. They were putting forth factual evidence so that they could prove that there was lies, so they could get a hearing on the factual evidence. That's step one. It wasn't just like a motion hearing. But the other part that they forgot is, in the past, there has been many hearings in this case, and those were motion hearings, and most of them were motions to compel. Motions to compel what? Discovery. So we know what discovery they were specifically looking for and for what reason they were specifically looking for the discovery. And the experts actually did get on the stand and testify to that. So when the defense brings up in their argument the discovery that they finally received and what happened when they plugged it in, well, yeah, it can really tell us the truth about the evidence. So I'm going to show you that clip, and then I'm going to show those people a magic trick, and let's see what they have to say about that.
With a clip that Pavarotti guy, now he's like the reckoning, I don't know. We'll figure it all out, but he's linked in the description if you want to follow with him, okay?
Added to that set of
Here we go. The revealing.
Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records. But based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IGG identification off to the side. But then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking, because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the cast draft report and in the cast final report, because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. It's misleading when you say.
Okay, now I have to say, listen, I enjoy watching Crime Circus as well. With the clips we're going to watch here, I am a little critical, and I'm just going to give you a warning on that, because I do believe he's gone full Kohberger, and which has taken the critical out of his thinking, in my opinion, which I think is the best thing about Drip Drop, but we'll get there. I'm just giving you a little warning.
Services this particular location. The records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. They absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening. BIT performed a drive testing. And so there were other bits of data that kept coming in so that they would know that was untrue. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house.
Now I got to hold myself accountable too, because my theory for a long time was the last pass in that neighborhood of that Elantra was Kohberger. And they were just pulling up near the King Road house to pick up some illicit substances, because I never could get a definitive statement from Ann Taylor that he was not near the residence ever. People argued with me, I argued back. Well, you know what? I can absolutely, when I hear evidence, like she just said, he was never at the house, that's definitive.
So this is a perfect place to stop right here and ask the question, are a lawyer's arguments and statements considered to be evidence? So when a lawyer is making arguments in pretrial proceedings and during a trial, is that evidence in itself? Now, there's no good visual here or anything. The audio isn't even that great. When I was recording this, I was not home. I'm not going to say where. But this is a really important point. And I think this is where some people go wrong in following this case and others. Is a lawyer's oral argument, is that testimony? Is the oral argument from an attorney to be taken as fact, evidence, or testimony in a case, in a trial, in pretrial proceedings, and anything having to do with a trial? The answer is no.
Boy, you're right, Miss Obsession. That answer is no. That's not testimony of evidence. No, that's not an expert witness, except for one thing. I know you're obviously very smart. You got a PhD, I think you said. But when you are listening to the lawyer and they're telling you about the information that they finally got from discovery that you clearly heard an expert witness ask for, and then you hear that lawyer say what happened once they received that discovery and they plugged it in, and it says that it proved that law was lying and they knew that, well, then, yeah, you can kind of take that testimony as fact, I think. And let me show you a magic trick that I can do that even with your advanced education you can't do.
And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. They also changed that quite a bit, performed a drive testing. And so there were other bits of data that kept coming in so that they would know that was untrue?
He had to have the AT&T CDRs, the full 6 months, a tower list to make some conversions that I'm seeing on the report, and also drive test data, which would be another form of source data, and then a mapping platform to ingest the drive test data into, to analyze it, to create these shapes that are then put into the draft report.
Can you tell if drive testing was done to create that cast draft?
Yes, there's images in the latter part of the report up around slides 100 and above. I believe there's a total of 4 images that were populated to that report that would require drive testing.
They also changed that quite a bit, performed a drive testing.
And also drive test data, images that were populated to that report that would require drive testing.
See, the reason I can do that where these overly educated people can't is because I have studied this case. You see, what you heard there was a motion to compel hearing done last year where the defense put their expert on the stand and he testified to the fact that the law enforcement used drive testing to complete their draft report and complete their final cast report. He specifically went through and asked for those specific things because they couldn't get them in discovery. And then after that hearing, the judge ordered that they should get those things in discovery. So when Ann Taylor says, and as we got the drive testing data and completed putting that into it, it further verified that those things were true and law enforcement knew that. So yeah, when I hear those things and I know what I've already heard in the case and read and seen and investigated, yeah, I can make the statement that what she's saying is in fact a fact. Now, for those of you out there though that just passively watch it and you're an attorney and you go, well, they're just making an argument. Well, that's all you see because you ain't paying attention to this thing. So you want to come at me, you better be prepared to have your information when you come at me because I'm going to outdo you every time because I know more than you do. Okay? And that's not me being prideful or boastful or conceited. I've just studied this thing in every possible way you can study it to where your little meaningless critiques are. Anyway, so I wanted to get that pass. Hope you liked that little magic trick I showed you. And I don't know. Maybe they should really dive in and see what I'm talking about before they try to discredit what I'm talking about. It never looks good on them, does it? Now that we got all that stuff passed, we're going to get into why we really are doing this video, and that is for some eye-popping information on the investigation. And it's funny how all kinds of things seem to correlate between events in the outer skirts of this case and events in the case. So what I'm going to do in this one now is I'm going to show you some compelling comparisons using things that happened in the public record, dates, times, and let's just see if there's any correlation. And, you know, I think I'll point out something, even a guilter doesn't want to say it guy pointed out that equally corroborates everything I'm about to say. Hold on to your hats. First, it's important for us to go all the way back to May 16th, 2023, because if you remember, that is when all of a sudden, instead of a preliminary hearing for Bryan Kohberger, a secret grand jury was convened and they indicted Bryan Kohberger. Now, through all of the court documents, the defense had to fight tooth and nail for a long time to even get all of the transcripts of the grand jury hearings. And I believe once they got all those transcripts in, it let them know the direction that they needed to take in the case as far as their investigation. You see, because at this time, another odd occurrence had taken place. And you can see about 2 months in jail and 5 days before they were to face trial on charges related to the overdose death of the 22-year-old Centralia man. 2 suspects were released from Lewis County Jail on Thursday after a judge dismissed their cases. The co-defendants, Emma Bailey of Moscow and Demetrius Robinson of Tacoma, were each charged in March with 1 count of conspiracy to commit violation of the Uniform Controlled Substances Act in Lewis County Superior Court following a joint narcotics enforcement team JNET investigation. On Thursday, May 25th, the Lewis County Prosecutor's Office filed motions to dismiss the cases against Bailey and Robinson without prejudice, meaning the cases can be refiled in the same court of law. The hearing where Judge Yoli Yeager heard Meyer's dismissal motions was scheduled as a trial confirmation hearing for the 2 co-defendants ahead of May 30th trial. The date of the trial has since been canceled. In the written motions, the prosecutor's office stated the dismissals were based upon the subjoined affidavit of counsel, adding, "In the interest of justice, your affiant respectfully requests the court grant the motion for a dismissal without prejudice." The specific reason for asking the cases be dismissed were not clarified in public court documents. Bailey and Robinson were arrested on Tuesday, March 21st, as part of a joint narcotics enforcement team JNET investigation into the overdose death of a 22-year-old man in Centralia. But it's these words that I think are so familiar to all of us in the case. You see this right here? In the interest of justice. Well, where do we hear all of that in the Kohberger documents? It's whenever something is sealed, right? We don't want to disclose this information because it would impede justice. And why would the dismissal motions come from the prosecutor? And why wouldn't they say why they dismissed these charges? It just doesn't really make any sense. And then, of course, the without prejudice, meaning the cases can be refiled in the same court of law. Well, they do that just in case the defendants renege on the deal that they've made. So they better go through with it or they'll just reinstate those charges. But the specific reasons for asking the cases to be dismissed were not clarified in the public court documents. I bet you they weren't, because you know what this is about. And one only has to plug in some dates on a timeline, and it only takes a couple to understand the correlation here. On May 16, 2022, a grand jury indicts Bryan Kohberger. On May 25th, 2022, charges are dismissed against Emma and Demetrius. And then coincidentally, directly after they dismissed those charges against Demetrius and Emma, Kohberger's investigative team starts their investigation. And where do they start it? Seattle, Washington. And how do we know that? Well, because those investigators gave an interview with Howard Bloom, and he used his key words. Here's what the defense is going to try to do. Let's read. And again, this comes from Howard Bloom's book, and more to the point, the only truthful chapter in his book, which is the last chapter, where he discusses the defense's strategies. The defense investigators' first stop was the Seattle DEA field office, and the overview they offered was by all accounts a tale of cutthroat international intrigue. It was the story of a pipeline that ran from China, where the fentanyl precursor chemicals were produced, to the sinister Sinaloa and Jalisco cartels in Mexico, which manufactured the drugs and then smuggled the too often lethal product to their distributor networks in northwestern urban hubs such as Seattle and Spokane. Next, with the eager help of a freelance army of small-time distributors, the drugs reached into the seemingly wholesale all-American counties and college towns like Moscow, Idaho. That was the view from 1,000 feet, but Sheriff Brett Myers, head of the Quad Cities Drug Task Force, a multi-jurisdictional team propped up in part by federal money, whose territory included the university towns of Moscow and Pullman, along with Lewis Clark State College in Lewiston, Idaho, offered a ground-level account, and it was enough to give anyone whose child was heading off to college in the area the willies. Was some sort of similar intrigue going on in Moscow the night the 4 students were unalived? The sheriff was not involved in the investigation and therefore can only speculate, but his was a local lawman's informed conjecture, and a resonating one. Could it have been a drug-related case? I can't rule it out. It's not improbable. From what I know, that would answer a lot of questions. You don't have to be a brainiac with 4 PhDs and a big platform to be able to figure out the final keys to this case. And it's M&D. So be looking for that, because you can bet that's going to come up soon. I'm about to check the court docs, see if we have anything new that's popped up. I know some more things popped up on the case summary last night, but I'll do that. And if there's anything to report, I will report it. But in the meantime, please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.
Until I